SwayamPrabha. Digital India. Educated India.
Good morning viewers, I am Dr. Ashwini Siwal from Faculty of Law, University of Delhi. I am here to discuss a very important topic titled Artificial Intelligence and Intellectual Property Interface, and this topic is lecture number 8 in the series called Law, Science and Technology. We already discussed the application of artificial intelligence in the context of Indian legal judgments or in the legal field in India and abroad in lecture number 7, but this is lecture number 8 where we will talk about more complex issue, that is the interface of intellectual property and artificial intelligence. Well, many of you must be wondering how these two are related and what is their interface. Well, dear viewers, artificial intelligence is altogether a different field when it is compared with intellectual property. Intellectual property basically is a field of law which confers monopoly or which confers exclusive right to the inventors or to the creators of certain works as stipulated in the different legislations pertaining to intellectual property. On the other hand, artificial intelligence, as we discussed in lecture number 7, is basically the intelligence to be embedded into the machines by the human intervention, or sometimes even without the human intervention, for decision making, for ability to reason, to be decision or problem solving features it may have, and so on and so forth. So, but what is their relationship or what is the interface between these two different fields? Let us have a look at it. So, first of all, I will tell you what all I am going to cover in this particular lecture. The topics which will get covered are as follows. We will first understand the importance of the intersection of IP and artificial intelligence. IP here stands for intellectual property. It here stands for intellectual property, and AI is artificial intelligence, right. We will see their intersection and understand the importance of this very important intersection. So, in this particular lecture, we will have the look at understanding artificial intelligence, the definitional contours, then we will cursorily look at types of AI and its impact on society and industry basically. Then we will learn some basics of intellectual property in the context of AI, right, in the context of AI. We will learn some intellectual property basics in the context of AI, wherein we will have a look at the definitions, types of IP, and then we will have a look at AI and IP, the current landscape, where our job shall be to look at the AI's role in creating intellectual property, and then to further look at the challenges in applying traditional IP laws to AI. Well, this is a very important aspect of this lecture, where we will have a look at the current landscape and we will see what is the role of AI in creating the intellectual property. We will further look at the challenges in applying traditional IP norms or laws to artificial intelligence. Will they fit well with the IP generative works, or we need to revise or improvise or amend our traditional intellectual property norms in order to apply them effectively or efficiently on the artificial intelligence enabled created works. Further, we will look at specifically, one by one, we will look at AI and patents, the interface of AI and copyright, interface of AI and trademark, interface of AI and trade secrets, one by one. Then we will see some ethical and policy considerations here, future trends and challenges, recommendations for IP strategy in the AI era, and ultimately in conclusion, we will have a recapitulation of key points and look at the importance of adapting IP laws to India. Right, this is the structure or the overview or the things that I am going to cover one by one in my presentation. So, let us start one by one. Let us have a look at the introduction to artificial intelligence in the context of AI. The interface between artificial intelligence and AI is a very complex and rapidly evolving area of law and policy. Here in this course, we will discuss some key concepts such as AI as an inventor. Well, one of the key questions in AI and IP is whether AI can be considered an inventor, and under the intellectual property law, inventors are conferred monopoly right, or you may say they are conferred with some rights, right. Some argue that AI is capable of creating novel and non-obvious inventions, it should be recognized as an inventor. Others on the other hand argue that inventorship should be limited to natural persons. Well, this contrast, that whether AI can be treated as an inventor, have bearing with the question of ownership, right. At the end of the day, whosoever will be the inventor will own it, correct, and ownership is important to reap benefits out of your work. Ownership is important to proliferate on your revenues, proliferate on output of your work. So, this argument or this conundrum, whether AI is an inventor or not, we will understand in this particular lecture. Ownership of AI generated work, as I said, can lead to complex questions, especially in the cases where AI system was trained using data and owned by someone else. So, who will own the copyright or the intellectual property, where the machine is trained on a data which is owned by someone else. So, ownership issues will stem and will lead to litigation. Then we will see what is the possibility of patentability of AI generated inventions, and it raises the questions about the patentability requirement of novelty, non-obviousness and industrial revolution. Some argue that if an AI system autonomously generates an invention that meets these requirements, it should be eligible for patent protection. Going ahead, we will look at the copyright protection for AI generated works, and then trade secrets and AI and ethical and policy consideration. Overall, the AI interface and IP interface is a complex and very evolving area, as I said earlier, and it will continue to raise new challenges, and AI technologies will advance with time, and so the challenges will advance with time. What is artificial intelligence and human intelligence? Let us have a look quickly, though the viewers may refer to lecture number 7 to understand more exhaustively and comprehensively as to what does AI mean and how it works, but here also for the purpose of the convenience of the viewers, I will explain what is artificial intelligence and how it is compared and analogized with human intelligence. Well, artificial intelligence is not easy to understand. It can be understood as the artificial ability to do things that require intelligence when done by humans, and intelligence is the ability to adapt one's behavior to fit into new circumstances, the ability to learn, reason, problem solving, perception and language understanding. So, it is an artificial ability, not a human ability, it is an artificial ability to reason, to solve problem, to perceive things and to understand language. If a machine acts as intelligently as a human being, then it is as intelligent as a human being. Computers can apply deductive reasoning, can operate through oral commands and indeed via speech recognition systems. They can converse with their user, but they can think also, and they are thinking. We all know that artificial intelligence has evolved to that extent where the machines have started thinking and have started showing emotions too. The ability of artificial intelligence systems today is quite remarkable. The following are examples of this system that aids doctors in the diagnosis of illnesses, makes therapy recommendations, one of which analyzes ultrasound images to aid doctors, and diagnosis of breast cancer and famous program Deep Blue that on May 11, 1997 beat the Russian chess champion Kasparov, something no one thought was possible. So, AI has gone to a different level or to a very advanced level, where it is helping or aiding doctors in diagnosis, in therapy recommendations, even in playing chess and triumphing over a world champion, right. So, these are the kind of advances which we have seen, and we all know that AI is ubiquitous, it is everywhere, it is in use in our cell phones, in our smart devices, even it is in use in the public governance, even it is used in the health sector, automobiles, everywhere you find the uses of the AI in some or the other way these days. Russian scientist Vitaly Waltz claimed to have developed the first artificial brain with the same intellectual potential as a human, producing a truly thinking machine. This is what he stated, that he has developed a human whose thinking ability is basically equivalent to a human, and it is a machine, right. This machine needs to be trained like a newborn child. It is extremely important for us to make it a friend, not a criminal or an enemy. So, what does it signify? That a machine may be trained for the benefit of the masses and for the benefit of the larger section of the society, but there is always a ethical or one apprehension which we all see, that it may become our enemy also, but though it is very far fetched or very hypothetical that the machine will become our enemy sometime. AI in its many variations will increasingly shape the geographies of our knowledge about ourselves in the world, make sense of our experience as we interface with the digital and real entities, decide what we can access and curate what we can and do care for. The prior hierarchies and vulnerabilities that already signify our episteme risk becoming further datum for the systematically variable outcomes that will be installed by the logics of the machine. So, we all understand that AI has developed to that extent where the concerns regarding its usage, especially resulting into advantages as well as disadvantages, are being brainstormed, and we all know that the father of AI, John McCarthy, who defined AI as science and engineering of making intelligent machines, and he told that, or he summarized that AI is the ability of a machine to perceive and respond to the environment independently or perform tasks that would typically require human intelligence. Just as machines have relieved humans of much of the burden of physical labor, AI will relieve humans of their use of cognitive processes, but not fully, partially. If changes occur to the human cognitive processes, the law will likely need to change accordingly. Now, this is very important for us to see, that when there will occur the changes to the human cognitive process, then the law will be required to be changed. But how will you change that law? Because law cannot be changed overnight, unlike technologies which are coming into the existence every now and then, and law on the other hand is more or less static or rigid, which requires lot of deliberations, and parliament makes or amends the law after a long procedural formalities. So, our laws are required to be reshaped and modified, especially in light of the fact that AI or some other such technological developments are taking place. And when it comes to IPR, basically, or intellectual property rights or intellectual property law, I will tell you that AI permeates or intrudes into many important aspects of intellectual property regime, especially the right of the inventor or the ownership of the particular invention, as well as on patentability or copyrightability of a particular subject matter, and so on and so forth, which we will going to discuss today, right. So, let us come to AI and law. Let me tell you or take you to the history of the invention of a computer, programmable computer, which was not invented until 1941. German built Z1 developed by Konrad Zuse with computing power was less powerful than our mobile phones. By way of comparison, the computers used in the first Apollo space mission had 2 KB of memory operating at 1 megahertz speed. The latest generation iPhone has 256 KB of memory and operates at 1 gigahertz, and yet today, some 70 years later, computers had attained the level of intelligence of modern human brain, a task which took mankind 200 million years. To that extent, the computer was rightly regarded in 1977 as nothing more than a tool, and legal provisions were made accordingly. The modern artificial intelligent computer is substantially more than a tool, and accordingly those provisions are no longer valid. Alternatives need to be considered. This is what I told you, that we need to think about bringing the changes into our law, because there are taking place rapid changes and developments in the way the technological developments are taking place, and the AI is evolving. So, what is the legal quagmire here? The first and the foremost is the long parliamentary procedure for the amendment in the laws. Laws cannot be so easily amended, and further some of the very important questions which we are supposed to ponder over in the context of IPs or in the context of intellectual properties. Well, can AI technologies be subject matter of protection under IPR? And we know that within the AI there are taking place lot of inventions. Within the AI realm, right, there are taking place lot of inventions. Are those inventions protected under IPRs? Then another quagmire is, can the results produced by AI be a subject matter of protection under IPR? Another question, the results produced by AI will become the subject matter of protection of the IPRs or not? The fundamental and the foremost is, can the inventions in the AI technologies be protected? The second concern is, can the results produced by AI be conferred a intellectual property protection or not? And lastly, what are the challenges as to the protection of AI under IPR? Right? What are the challenges? We need to look at the challenges. Well, let us have a glimpse quickly, on intellectual property rights. So far, we have understood what AI is. We have understood three important, three important legal questions or legal technical niceties, which are posing challenge. And then, I am here to tell you what is intellectual property, so that we can understand their interface very well. So I told you that there are issues pertaining to ownership and inventorship, but we need to understand what intellectual property is all about in a very quicker fashion. All intellectual property rights are regarded as what? Products of mind, or you may say they are knowledge goods. They are knowledge goods, and we know that knowledge goods cannot come into the existence without intelligence, and here we are talking about artificial intelligence. So, all intellectual properties which are basically products of mind or output or offshoot of your intellect, they are offshoot of intellect, right. So, can they be given an intellectual property protection? It is said that man is different from a beast, and so is the knowledge produced by a man is different than the animals. But can it be said, and will it be true to say, that knowledge produced by computers is different than the man? This is something very perplexing, because at times computer is flawless, at times it is seen that computer and the knowledge produced by the machines is more comprehensive, is more flawless, is more of utility than the knowledge produced by the humans. Moving forward, let me tell you what intellectual property is according to the word intellectual property organization. Many of you who are law students or who studied law, they know what does intellectual property mean, but let me simplify it for you. Intellectual property according to WIPO, World Intellectual Property Organization, mean all inventions, literary works, artistic works, symbols, right, or in short you may say namely patents, copyright, trademark and design, they are called intellectual properties. And under the intellectual property system, we have a system of a setting of incentivization, right. We have a setting of or system of incentivization, people rewarding people for creating knowledge goods, for creating their intellectual creations, be it patents, copyright, trademark, or for that matter any of the intellectual properties, industrial designs or semiconductor layout designs or integrated circuit designs, or for that matter geographical indication, right. The basic concept is that innovation has to be rewarded. So, here in our context or in the context of today's lecture, will AI technologies or inventions in the AI technology will get the intellectual property protection and will be rewarded or not. By giving an inventor a certain monopoly over what he has created, we can allow him to capitalize on his invention, earn his just rewards and hopefully stimulate him and others to further invent, which basically spurs the innovation, right. The idea here is to help the inventors or encourage the inventors and motivate them, and this leads to what, spurring of the innovation, or more and more innovations will take place, right. This remains, this intellectual property basically is an area which remains at the cutting edge of technology, and legislation in this area needs to keep pace with the advances in the technology as well as the advances in the AI technology, right. So, this is one such field of law. IPRs are one such field of law which have a cutting edge you may say cutting edge niche area, or you may say cutting edge area where legislations required to keep pace with the advances in the technology. What is a regulatory quagmire? When it comes to regulatory quagmire, establishing a legal framework to protect intellectual property right in the context of AI is a complex challenge due to the lack of the existing legislation. There is no law categorically or explicitly addressing intellectual property issues of AI, right. There is no law categorically explicitly covering intellectual property protection of the AI generated works or AI generated subject matters. So, clear regulations must be written and implemented in order to determine the rights of originators and users of AI technologies. But is it so simple? Is it so easy? No, it is not so easy, because there are arising many technical and complex issues as well as many ethical issues, which we will discuss shortly. For example, a report released by Center for Internet and Society, written in October 10th 2020, recommends that when appropriating intellectual property rights, the degree of human intervention and autonomy of the AI should be taken into account. AI creations, legally protected or not, this is what we are supposed to see. This would serve to protect the originators of AI from exploitation and in turn encourage the development of new and innovative AI technologies. So, this is clear that the recommendations have come not just from only one report. In fact, I will say recommendations are coming across the globe from several sources of providing autonomy of the AI as well as of taking into consideration the autonomy of the AI or into account of the autonomy of the AI when making the intellectual property laws or when deciding on the intellectual property protection on the AI related works. Now, coming to different intellectual properties one by one. As I told you that there are several intellectual properties which have a bearing with the artificial intelligence and which have the involvement of the artificial intelligence. Let me first quickly tell you what are different intellectual property and what do they protect. Well, patents are basically available on new products and processes and it is conferred when a new product or a process involves an inventive step and it is capable of industrial application, and it is of some utility, right. On the other hand, trademark is another field of intellectual property which allows the conferment of some exclusive right on some symbols or word, logo, letter, numeral, or basically on some indications on the basis of the distinctiveness available in the particular mark or an indication, and on the basis of some other parameters, but basically it is conferred on word, letter, numeral, logo, device, symbol, etc. And similarly, copyright is another field of intellectual property regime or intellectual property rights, wherein the copyright is conferred on original literary, artistic and dramatic works, or on cinematograph or sound recording, and originality in that particular work or in all the works, be it literary, artistic, dramatic or any of those, is one of the prerequisites in the case of copyright. So is the prerequisite in the case of patents. Originality is a prerequisite of copyright, but novelty is a prerequisite of patent law. So we have understood different kinds of intellectual properties. Similarly, industrial designs is one of these properties under the intellectual property regime, where IP is to be conferred, and basically it is conferred on what? On configuration patterns, 2-dimensional, 3-dimensionals, etc. Only on the basis of what? That the design is new and it is not a fraudulent or obvious imitation of the existing design, or at least the application of the existing design is on a new article, right, in a new way. So these are some of the intellectual properties on which we may see the application of AI or interface of AI. Starting with the patents, well, I told you that patent is a monopoly granted by the state in respect of a new invention to prevent anyone using the exclusive rights granted to the patent owner. This is very simple. It is granted to the inventor on a new invention. As I told you that here novelty is the prerequisite, right, and it may be granted to the owner. Can AI be the owner? Now this is the question. Can AI be called the owner of the new invention? It may be, it may not be, it depends, we will see that. Then the protection exists for a period of 20 years, the patent protection from the date of filing, and it is granted through lot of rigorous procedures. After following the lot of rigorous procedures as set out under the patent law, novelty is checked, non-obviousness is checked, its industrial application is checked, and then finally the patent is conferred on the basis of those procedural requirements for a period of 20 years. And this protection is reserved for inventions that satisfy a very stringent qualification process, as I told you: novelty, non-obviousness and utility. It has these requirements to be fulfilled: novelty, non-obviousness and utility, or capable of industrial application may be understood as a utility, right. The concept of inventive step encompasses the concept of an intelligent deduction. It is here we start talking about the interface between patent and AI, interface between patent and AI. What is that interface? Let us have a look at it. The concept encompasses the concept of intelligent deduction. It is in this area that the conflict between an invention generated by a human and one created by an AI computer will impact. The most widely accepted test for this requirement was set out in the case of windsurfing by Oliver Lord Justice and further modified by Jacob Lord Justice in Pazzoli versus BDMO SA. Well, let me take you to this and explain it. In this case, those following things were discussed, which are there on the screen. Whether there is a mention of a human input in the governing legislation, the patent law of no country basically recognizes that AI can be the inventor. It recognizes only the owner, who is basically a person, have some juristic personality. It or for that matter no law, no governing legislation on patent anywhere in the world recognizes machine as the inventor or recognizes any machine enabled or AI enabled tool as an inventor. It basically recognizes humans as the inventors. Then at any point in the statute or the test, is there any requirement per se for human thought simply for this inventive step? We also have seen that in legislations across the globe, at any point no mention is there for human thought, of machine thought. Everywhere we find the human thought finding the predominance for any inventive step to be checked by the patent offices. So, this also causes a problem or also indicates that AI may not become the inventor in the eyes of the law. Similarly, are there any specific provisions dealing with patents arising from the product of an AI computer, the computer generated works? So, these remain to be considered in accordance with the general requirements for patentability, just like any other invention, unlike the situation with regard to copyright, which has specific provisions dealing with computer generated works, which we shall be considering next. So, look at the issues which have been framed in the context of AI and patent interface. The first and foremost is about the inventorship, as to who will gonna be the inventor. Can the machine be given a patent protection? Well, the answer to this is that no law recognizes machines as inventors. Laws are clear that only humans can be the inventors. Law, nowhere in the word law is there which specifies that a machine may be the inventor. So, this is a one complex issue, and laws pertaining to patent, they are categorically or explicitly writing that any person may make an application. They are not saying that any machine. The words used are any person may make an application for a patent, and it may be granted to a person. It cannot be granted to a machine. Neither a machine can file a patent nor it can be granted to it. Therefore, can it be argued that it requires a human intervention? Well, I will say yes, it requires a human intervention, but what about those works where there lies no human intervention? Can they be protected? This is the question. There are certain works which are generated typically by AI, no human intervention in the creation of those works. And how has it become possible? The concept of generative AI explains it very well. The concept of generative AI explains that the AI may generate or learn itself and may generate the work without the human intervention. No technical human intervention is required for the creation of those works. So, at that juncture it becomes more complex as to who will gonna get the protection on that work which is created without human intervention totally by the artificial intelligence. Or this was simply a term of convenience by the drafters. Well, if we think that person or patent conferred to person and then requires a human inventors, these are the words which are appearing or reappearing in the patent laws of most of the countries. Are these terms which just simply picked by the drafters? Didn't they think about or foresee about time when machines will replace the cognitive capacity and will be having the capacity equivalent to the humans to create the patented works like new inventions, products or processes for that matter? Thus, the statute explicitly recognizes the possibility of an employee created invention belonging to the employer, which in many instances will be a body corporate, a non-legal entity given the right to be treated as an inventor by an operation of the law. Well, answers to these questions are very complex. Most AI related inventions are software related inventions. This means that the patent eligibility of AI related inventions mainly depends on that of a computer software, right. So, we all know that mostly AI related inventions are software related, and technically in India software patent is a new trend. Our patent law confers a patent protection to computer related inventions, but not directly to the softwares. But in US softwares are given a patent protection explicitly, but for us when looking at the AI and patent interface, it is very important to note that AI related inventions are software related inventions, which means that the patent eligibility of AI related invention mainly depends on that of a computer software. Here in India, computer programs are copyrightable, and computer related inventions CRIs get the patent, right. They do not get the they do not get the patent protection. So, it depends largely on what, that whether a particular AI generated or AI related invention is a computer program or is a computer related invention, then it will be determined whether it will get a copyright protection or a patent protection basically. So, defining or deciding the particular nature of the work or of the subject matter, it becomes very important, right. Moving ahead, let me wipe it out for your convenience. Autonomous AI generated inventions would raise the level of the inventive step further, which may make it harder for human inventors to obtain patents. One may worry that autonomous AI generated inventions might de-incentivize human inventors. However, even if human inventors were discouraged, endless amounts of autonomous AI generated inventions would still be forthcoming. Well, this is another challenge, that if we will start conferring the patent to the AI related inventions, then the standard or bar, the bar of or the threshold of inventiveness will get raised. The threshold will get raised. Human might not be able to think to that extent or to that level or to that threshold, which AI is basically thinking, or automated AI generated inventions may think, right. So, it is another challenge in the case of the patents. Then there are various types of AI generated or related inventions. Let us have a look at those inventions of AI technologies, AI assisted inventions, AI generated inventions. The first type here is an invention of AI technologies which is created by humans to improve AI technologies themselves, right. I told you in the beginning at the outset that what will be the fate of AI technologies or inventions in the AI technologies. Well, as I told you that it largely will depend on whether it is a computer program or a computer software or a computer related invention. Only then the kind of intellectual property shall be conferred, or accordingly the kind of intellectual property shall be conferred. Then second category here is AI assisted inventions. Well, in this category which is created by humans with the use of AI. In this second time, AI is a tool is used to help humans create inventions, and AI is applied to various fields, right. In both first and second type, we see that both are created by humans, or there lies a human intervention, whoever they may be or wherever they may be. So, without human intervention, first two kinds of AI related inventions does not come into the existence, but when it comes to third, which is generative AI, we see that no human intervention is needed or is required or is there. So, what will be the fate of that kind of invention? Who will gonna own the patent, whether the machine or the human. At the first instance, there must have been some human who have transpired that particular invention, who have created that particular AI related work, but later on it has generated its own learning, its own thinking ability, perception, etc., and has created some work. So, who will gonna own the intellectual property on that AI generated inventions, right? These are some complex issues, very complex to be summarized, right, in one particular straightforward dimension. On the other hand, the third type, which is AI generated invention, is autonomously generated by AI. This does not necessarily mean no human intervention at all. As I told you that there lies some intervention at the basic level, rather humans may give AI instructions or orders such as to generate something like whatever unlike the first and second types. There may be few AI generated inventions, partly because creating inventions generally requires more complicated technologies than creating works such as paintings or music. However, it may not be impossible. Well, it is also understood and has been accepted that there lies even in the third category some human intervention, right, at the basic level, which is to be recognized. We have some stories to explain this interface. Story of Dabus, AI called Dabus allegedly autonomously created two inventions, food or beverage. This is a artificial intelligence, Dabus is its name, and it created a food or a beverage container and devices and methods for attracting enhanced attention. They explained that Dabus contained several neural networks. I mean, the applicants of this application for the intellectual property, they explained that Dabus contained several neural networks that had been trained with general information in various fields. Then the first neural network generated novel ideas, and the second neural network not only identified sufficiently novel ideas, but also generated an effective response to selectively form and ripen ideas having the most novelty, utility or value. In the above mentioned two inventions, Dabus only received training in general information in the fields and proceeded to independently conceive the inventions and to identify them as novel and salient. The applicants argued that it was not a person, but AI which identified the novelty and salience of the inventions. Accordingly, they asserted that AI should be deemed an inventor. So, the look at the gist of it, that the applicants here asserted that the AI has itself identified the novelty and salience of the invention. So, the inventor should be the AI or the machine itself, and that since machine could not own a property such as patents, AI's owner should be entitled to obtain the patent rights. However, in December 2019, the EPO refused, the European Patent Office refused the two applications on the ground that they did not meet the requirement of the European Patent Convention that an inventor had to be a human being. So, EPO says and reiterates that the inventor has to be a human being, not a machine. The UK IPO, United Kingdom Intellectual Property Office, also refused these applications on the same grounds. The inventor in the UK Patent Act is a natural person, that is a human and not an AI machine. Although the Japanese Patent Act does not say so explicitly, it provides that an inventor of an invention that is industrially applicable may be entitled to obtain a patent for the said invention. The inventor is, that provision is considered to be a person, not AI. Therefore, autonomously AI generated inventions, if any, could not be protected in Japan either. Japan does not protect, UK does not protect explicitly, even European Patent Office does not protect AI generated inventions, autonomously AI generated inventions. So, this is the uniform situation across the globe, and with this particular story of Dabus, it is clear that no patent can directly be conferred on a machine, because at the end of the day every law of each country or laws prevailing in each jurisdiction requires that the person has to be a natural person or a human and not a machine or a AI to get the patent protection. When it comes to patent prosecution and AI in India, we have some more complicated issues arising, and through these complicated issues we can understand the interface more clearly. We see that there is an impact of new technologies such as blockchain and AI on the representation of the invention before the patent office and its consequential effect on the decentralization of the functions of the patent office. It is important to consider the impact of AI on following: standard of novelty, inventive step, enabling disclosure, fair basis. Well, as I told you that the standard or threshold in the case of AI related inventions will go very high, threshold will be very high, and no human imagination can meet that threshold. Similarly, standard of novelty will be very high in the case of a AI enabled invention or autonomously AI generated invention. So, these few things are posing the problem even at the patent prosecution. Patent prosecution means at the time of the patent application examination or its publication or its scrutinization, some complex issues are going to arise or are bound to arise when AI is applied to such things. Now, coming to the next aspect, that is AI and copyright. Well, here again we need to first understand what does copyright mean. As I told you, copyright is conferred on what? On original literary, artistic, dramatic, musical or cinematograph works or sound recording, right? On cinematograph works, cinefilms, or you may say sound recordings, right? So, copyright is basically a form of intellectual property only, and it is conferred on literary, dramatic, musical, artistic works, etc. Deemed to include computer generated works. As I told you, copyright is conferred on computer programs in India, provided they fall into the recognized categories and provides the author with certain rights. And as I told you that it is conferred on original literary works or original artistic works, original cinefilms, original sound recordings, etc. Such rights include preventing third parties from copying, from issuing the copies to the public or lending the copies to the public, or adaptation of the particular work to the public. And here we see in the copyright law that there is no formal registration required. It is a automatic protection regime where the copyright may be conferred automatically to the owner of the copyright or to the creator of the copyright. But now here comes the question, will AI own the copyright or not? If autonomously generated AI creates a copyrighted subject matter like a literary work or artistic work, we have all seen in the recent past that even news in the print media are written and authored by the artificial intelligence employed tools or enabled tools. So is the case with news reading these days, where AI inbuilt robots or chatbots are used for printing or for dissemination of the news, etc. Right. So here arises lot of copyrightability issues. Who will gonna own the copyright protection on those works? The way we saw in the cases of patents. So AI generated works implicate copyright issues which needs to be addressed. For example, the Copyright Office receiving an application for a work described as autonomously created by a computer algorithm running on a machine. The Copyright Office has to consider not only the copy of the work, but also the AI system used to generate it, and the degree to which the creator of AI system should be considered a co-author. Now, in some of the cases AI is considered or has been considered as co-author in India. I will give you examples shortly, but by looking at the copy of the work in question for copyright protection and also the AI system used to generate the particular work, the copyright offices have started conferring the copyright protection even to the machines, but not as the primary authors, but as the co-authors. India has become the first country to provide joint authorship to AI along with the creator of the program. Raghav is a painting application which is AI basically, that is known to have created the painting Suryast. You may check it on the Google. This painting is a combination of Vincent van Gogh painting, that was Starry Night, and a photograph taken by Ankit Sahni, and he claimed authorship on this painting, and Copyright Office recognized and conferred copyright protection to Raghav in India. There were two applications filed by the creator of the AI system Raghav, first one claiming sole authorship for the work generated by it, and the other one claiming the joint authorship of the AI and Ankit Sahni. After filing of this application, a parliamentary standing committee on commerce was arranged and made intellectual property rights their main point of discussion during 161st report. It was determined in the report that the current laws of the country are not competent to protect the rights of the AI generated work, and suggestions were made to accommodate such rights under copyright laws. So, the Copyright Office has started recognizing the co-authorship of the AI, or you may say of the applications based on the AI, autonomous generated works in the form of a copyright, and it is also reported and also noticed or noted here that our existing law is not adequate enough. The current laws of the country are not competent to protect the rights of the AI generated work. So, suggestions were made to accommodate such right under copyright laws. When it comes to trademark and AI, let us see the interface here of the trademark and AI. As I told you that trademark basically is conferred on what? On marks or indications which are which are basically the indications used in the course of trade to indicate or signify the origin of the goods and to prevent the consumers, innocent consumers, to be duped by the unscrupulous entities in the marketplace. They are the indications, or in technical terms, in the legislative terms, in fact I will say, any word, letter, numeral, logo, device, symbol, color combinations, shape of goods, etc. may be conferred a trademark protection if they are distinctive or if they can be graphically represented. Where does the AI or problem of AI, interface of AI with the trademark lie? Let us understand that. Can AI systems infringe on trademarks? Well, I say yes, because AI systems basically may produce or replicate the trademarks which are deceptively similar or confusingly similar to the original trademarks created by the humans. And on certain services, as well as especially in the virtual space, on certain services those counterfeit trademarks produced by AI, created by AI, may be applied or may be used, which leads to confusion, which leads to consumers loss. So, it is very much possible that AI system may infringe on trademark, right. So, there are a lot of challenges here. Can AI system cause confusion among customers? As I said, yes, it can cause confusion amongst the customers, or any confusion created by AI system, right, will go unchecked, as our law does not recognize AI's involvement into creation of a confusingly similar or deceptively similar trademarks, and our law does not recognize even any right or obligation or a duty of the AI. So, these are some of the challenges which we may face in the cases of the trademark, that confusions may prevail, deceptive trademarks or counterfeit trademarks may be used in providing the services in a virtual space specifically, and even in the physical terms. So, customers may be at the huge loss. It needs to be checked, and the law is accordingly needs to be revised or modified. Can AI system alter the behavior of consumers? This is another challenge in the case of a trademark law. As I told you that trademark law is consumer centric. It has a function of empowering the consumers, right. It has a utility of empowering the consumers by either branding a particular trademark or by inculcating a particular trademark into the consumer's mind. So, a consumer may get duped or deceived into the hands of the unscrupulous entities, and AI system sometimes, when most of the times in today's world, in the digital age, we are using more virtual means or mediums, or we are using digital means or mediums to even do our business or commerce or communications, right. So, our behavior may also be altered by the AI or systems enabled by AI, right, which may lead to further deterioration into our intellectual property protection, further leads to intellectual property infringement. To whom does the trademark or slogan suggested by an AI tool belong? There may arise the questions, who will own the ownership, or who will own the right on a slogan suggested by AI or a trademark developed by AI. Again I will say that here again the same situation prevail, though no trademark law of any country or our trademark law for that matter make any AI or autonomously generated AI as a proprietor of a trademark, or it does not recognize any machine as a proprietor of a trademark. So, basically that trademark created by the AI or a slogan suggested by AI will be owned by the human, because at the end of the day it is the human intervention which has caused it to happen. So, laws here in India are explicitly using the word whoever causes the work to be created, he or she owns it. Whoever causes the work to be created, he or she owns it. So, it is the human who has basically programmed the machine, but when it comes to generative AI, this particular principle will become OTOs or will become useless, because that is a generative AI. The human intervention is minimal or no human intervention lies there. In such cases, it will be very difficult to decide as to who will own the particular trademark or a slogan, right. So, basically at this juncture the user who entered the command will get a trademark, right, or who has caused the work to be created will get the trademark. Similarly, in the case of design and AI, right, I have told you that designs are conferred on configuration, patterns, lines, on 2D and 3D designs, etc. Requirement for protection of design is very much there, because it is also an intellectual property or a intellect of an offshoot of an intellect of a person. Design may be produced with AI assistance or autonomously by AI tool. So, the same questions will arise, how AI can impact design law and who will own such design which are autonomously created. Can results generated by an AI tool could be protected as a design? Well, as I said that the humans who have commanded or who have caused that design to be created will get it, but in the cases of generative AI, any design created by a generative AI, it shall be very difficult to comment, and the AI will still lie to some human, or nobody shall be conferred a right on it at this juncture. So, who should apply for the design, the user or the developer of the AI tool? Well, I say that it is the developer of the AI tool who will apply, not the user who will apply, right. Then coming to all quickly or to a very pertinent observation here, whether AI has a legal personality. As I said that legal personhood is an artificial construct. At this juncture AI has no legal personality, but by making the changes into the laws, legal personality may be conferred to the AI as well, right. And legal personhood is not confined to human beings, its main purpose is to regulate human conduct. If tomorrow need will arise to conduct the artificial intelligence, then the same legal personality which is a artificial construct may be conferred to the AI, and there are several approaches in which we may tackle it, which I believe we may discuss in the next lecture or in a few more lectures pertaining to this. But at this juncture I will conclude by saying that it is very difficult to reconcile with the interface between AI and IP, because there lies lot of conundrum and quagmires, and it is not so easy to finalize or conclude that only humans can get the protection in the form of intellectual property. Rather, some artificial intelligence or generative AI, especially in the case of generative AI, some intellectual property protection may be made available, but at this juncture no country has started conferring except our country in the case of Raghav, conferred a copyright as a co-author, but we have lot of scope lying here for improvement and adjustment according to the need of the hour. Thank you very much for listening me patiently, and we will meet again in the next lecture. Thank you very much.